On October 9th, 1993, Tammy went to check on her son Kenneth, who was then 2.5 years old, napping in the spare bedroom. She thought she heard Kenneth calling her, but when she got to the room, she witnessed her son tangled in the bedsheets, gasping for breath and clearly in distress. Unfortunately, she was unable to free him from the sheets and desperately called 911. The 911 operator instructed her to perform CPR, but Tammy was too distraught to be able to follow the instructions. The emergency crews arrived and brought Kenneth to the hospital, where he was revived, but unfortunately suffered irreversible brain damage. Kenneth was taken off life support 3 days later and passed away. Tammy had given permission for Kenneth to be an organ donor in hopes that she could prevent other parents from suffering a similar tragedy. Dr. Charles Smith was considered the leading expert in Canada on criminally suspicious pediatric deaths in 1993. He was the director of the Ontario Pediatric Forensic Pathology Unit at Sick Kids Hospital in Toronto, and often lectured on pediatric forensic pathology to Crown Counsel, police officers, and coroners. He was to perform Kenneth's autopsy. Dr. Charles Smith concluded that Kenneth's death was not accidental, and less than 2 months after losing her son, Tammy was charged and arrested for the second-degree murder of Kenneth. Tammy Marquardt was born in Toronto, Ontario, mainly raised by her mother. After suffering sexual abuse from her mother's boyfriend, Tammy moved out of her house at the age of 17. Tammy, who was then 19, and her boyfriend at the time, Robert Nelson, were expecting their son Kenneth in the summer of 1990. Tammy's relationship with Robert did not last. Tammy eventually married Rick Marquardt, but unfortunately, Rick was abusive towards both Tammy and Kenneth. Tammy did have frequent contact with Children's Aid Society. Kenneth was never taken from Tammy, but she did willingly place him into care for 3 months to protect him from the current living situation at home. One important detail to note is that Kenneth suffered a number of serious health issues. These included asthma, pneumonia, and epilepsy. Epilepsy often caused frequent and severe seizures, which resulted in the hospitalization of Kenneth several times over the course of his short life. Dr. Charles Smith was the head of pediatric forensic pathology at the Sick Kids Hospital in Toronto for 21 years. In the year 2007, a public inquiry was completed on Dr. Charles Smith. Later in the movie, we will discuss the shocking discoveries that were made. For now, we will discuss Dr. Smith's expert testimony in Tammy's case. Less than 2 months after Kenneth's death, Dr. Smith concluded Kenneth's death was not accidental. At trial, he insisted that the cause of death was asphyxia, and Kenneth's death was caused by strangulation or smothering. This testimony was central to the prosecution's theory that Tammy had strangled Kenneth due to extreme frustration. Dr. Smith also suggested that the petechial hemorrhages, which are small red spots on the organs and tissues that had not been donated, were proof of his theory. Dr. Smith not only had no formal education or board certification to be a pediatric forensic pathologist, but as an expert witness, he would frequently give misleading statements and often tell lies on the witness stand. The jury also heard evidence about Tammy's demeanor at the hospital, the scene of the crime, and when she was being arrested. All of this information would likely be ruled inadmissible if the trial were to be held today. The judge did encourage the jury not to consider this evidence, but they had already heard about it from multiple witnesses. The defense counsel also chose not to call their own medical expert to testify that Kenneth likely died due to an epileptic seizure. We should also take into account that Tammy was denied legal aid funding to appeal her case. Tammy was tried by both a judge and a jury in Whitby, Ontario. As was just mentioned, Dr. Smith insisted that Kenneth's death was caused by asphyxia, either strangulation or smothering. This testimony was central to the Crown's case. The Crown saw Tammy as a young mother with little financial resources, lack of parental and coping skills, and had an extremely unstable relationship with Kenny's stepfather, Rick. The Crown also relied on Children's Aid Society workers that contributed circumstantial evidence to Dr. Smith's conclusion. Tammy testified in her own defense and maintained that she was innocent throughout her ordeal. The defense had argued that Kenneth had died due to an epileptic seizure, but no medical expert of their own was ever called to support their theory. On October 24, 1995, Tammy was convicted of Kenneth's murder. Sentenced to life in prison without the possibility of parole for 10 years, Tammy was shocked. Tammy then appealed her conviction to the Ontario Court of Appeal. On January 22, 1998, her appeal was dismissed by a unanimous court. Legal aid refused to provide her with more funding, and she was unable to appeal to the Supreme Court of Canada. Tammy began to feel hopeless, as she had now not only lost her son, but also her case. Beginning in 1991, concerns were being voiced about Smith's professional competence. In the same year, trial judge Justice Dunn acquitted a 12-year-old who was charged with manslaughter of a 16-month-old she was babysitting at the time. Throughout the 1990s and 2000s, Smith continued to receive negative attention, but in hindsight, the complaints were scarce, so he continued to practice. On June 7, 2005, Dr. McClellan, who was then Chief Coroner for Ontario, announced that a formal review would be conducted of criminally suspicious deaths that Smith had performed the autopsy for. Dr. Sacco was assigned to review Kenneth's case. In Dr. Sacco's report to the Chief Coroner, he concluded that Dr. Smith's finding of asphyxia was both illogical and completely against scientific evidence-based reasoning. He found that there was not sufficient evidence for the diagnosis of asphyxia to be made. He shouldn't have based this finding only on the petechial hemorrhages of thymus, pulmonary pleura, and epicardium, which are non-specific findings. Dr. Sacco suggested that the cause of death should have been given as unascertained. Dr. Sacco argued that the evidence Smith had given at Tammy's preliminary inquiry and trial was both misleading and unprofessional. In 2008, another doctor, Simon Ashby, who was the chief medical examiner for the province of Newfoundland, conducted a second review of the evidence and circumstances regarding Kenneth's death. Dr. Ashby agreed that Smith wrongfully attributed Kenneth's death to homicidal asphyxia and concluded Kenneth possibly died during an epileptic seizure. Dr. Smith suggested that the harvesting of several of Kenneth's organs prior to the autopsy was merely a minor inconvenience. Both Dr. Sacco and Ashby were critical of this. On February 10, 2009, Adwick brought an application for leave to appeal Tammy's case to the Supreme Court, as well as the necessary application for an extension of time to file the appeal. The next day, the time was granted. On March 12, 2009, Tammy was released from the Grandview Penitentiary in Kitchener, pending the decision on her application for leave to appeal to the Supreme Court of Canada. At this time, she had spent nearly 14 years in prison. April 30, 2009, the Supreme Court issued an order remanding the case to the Ontario Court of Appeal for Ontario to consider the fresh evidence and determine whether Tammy's conviction was due to a miscarriage of justice. Nearly 2 years later, on June 7, 2011, the Ontario Court of Appeal quashed Tammy's conviction and ordered a new trial to begin on February 10, 2012. Before the new trial even began, the Crown withdrew the charges against Tammy. This was likely due to the fresh new medical evidence provided by both experts, Dr. Ashby and Dr. Milroy, who was an expert retained by the Crown. Both of the doctors agreed that sudden, unexpected death in epilepsy could not be ruled out as the cause of death in Kenneth's case. Dr. Ashby also suggested 2 additional natural causes of Kenneth's death, which are both well known in infant and children who have inborn errors of metabolism. These 2 causes are known as medium-chain alkyl-CoA dehydrogenase deficiency and cardiac conduction defects.
Would you like the authorities to look more at Charles Smith? Do you think enough has been done in dealing with just what he got?
I don't think anything could vindicate. He has to live in his own personal hell. so I don't think there's anything really that could, that I or anyone else could do. Putting my name on the registry, so that way Keith and Eric...
The gout inquiry was extremely important for pediatric forensic pathology. It began April 25, 2007, and looked at 20-plus cases, all of which Smith had made serious inquiries into. Some of the findings made throughout the inquiry include the following. Smith lacked formal forensic pathology training or board certification in that field. His training was often described as woefully inadequate, which he often agreed with throughout the inquiry. He also received no formal training in either injury identification or the appropriate role of the forensic pathologist in the criminal justice system. All of his knowledge of forensic pathology, which was extremely limited, was acquired on the job. Dr. Smith was self-taught and held a minimum of forensic pathology education training. This quickly became a well-guarded secret among Dr. Smith's medical colleagues. The inquiry also discovered that Dr. Smith rarely attended the death scene, lacked relevant medical information before the autopsy, was sloppy and inconsistent with documentation during the examination, produced inadequate reports which were notoriously late, and often relied on social history information of those allegedly involved in the death to inform his conclusion. He often failed to record information, failed to preserve autopsy reports, misplaced or lost key forensic evidence and post-mortem exhibits, came unprepared for trial, and gave scientifically unsubstantiated evidence before the courts. Since communication was often verbal, a lot of details passed between police officers, coroners, and forensic identification officers were never recorded. This ultimately hampered the ability of the defense counsel to examine the basis of conclusions and opened up the real possibility that scientific experts became contaminated by the tunnel vision of police officers and Crown Counsel. Dr. Smith routinely invoked moral conjecturing to formulate his scientific findings. His moral judgments would then exclude those members of society who were seen to conform to societal norms. He views his role as to apprehend child abusers. Dr. Smith's targets were often women suspected of abusing their children, which may have raised suspicions among forensic pathologists, leading to a misdiagnosis of the cause of death. Dr. Smith often held sexist or classist stereotypes. He often focused on women who had ongoing involvement with child protection agencies. Smith and his colleagues shared a patriarchal view by constructing single mothers as evil, cold, selfish, violent, dishonest, and often addicted to drugs and alcohol, and who were likely to cause harm to their children either by negligence or direct physical harm.
Okay, so that's our focus tonight, the shocking case of a Toronto pathologist whose testimony sent a number of people to prison. How did it happen? What safeguards should be in place to make sure it never happens again? Joining me tonight to talk about this, to take your calls, criminal defense lawyer Joe Newberger, and welcome back to Legal Briefs, Joe.
Thank you.
Let's set the plate here, because this is not the Charles Smith inquiry, and I think people have to understand that. This is not an inquiry to find criminal or civil liability. This was an inquiry to conduct a systemic review of the practice of pediatric pathology, forensic pathology from 1981 to now. And all that's happened here is the Charles Smith cases, and he admits that he made mistakes, and nobody's going to take anything away from the effect that it had on the families. But it is pointing to a lot of things in that system. That's exactly what this inquiry is looking at, that were at fault. And I think we got to remember that.
Yeah, that's fair.
And when you look at this and you see it, I mean, there's so many issues to talk about. The issue of the expert witness and what that's like for somebody who is... Today, Dr. Smith said that his training was woefully inadequate. And yet when this man walked into court, and anybody who is an expert, a jury looks at them almost like they're gods.
Absolutely. What the public has to understand, and the judicial system has to understand, is that when an expert witness like that hits the stand, their opinion is so close to what we call the ultimate issue, guilt or innocence, that it is incredibly powerful. And it can sway a jury or a judge very easily, because a trier of fact, a judge or a jury, will look at it and say, well, the person's qualified as an expert. As a result of that, they come with all of that experience and training, and their opinion carries the day.
Exactly. And it's interesting. This is what he's asked with respect to that training to become this expert in forensic pathology. And he was considered by staff, by everyone in the coroner's office, etc. He says this, he's asked, how would you describe your training in forensic pediatric pathology? And he said it was self-taught, it was minimal, and retrospectively, it was hopefully inadequate. And that is very scary. And that's what people should understand when you're looking at this case, to look beyond Dr. Smith and look beyond what was happening in the system.
The difficulty, though, is, and I accept that, and that means there is some flaw in the system, and hopefully when we're talking about 2000 and onward, the training for these experts is much better and enhanced. The difficulty is when he took the stand, he didn't have the humility of somebody who had training that was inadequate. He spoke directly on the issue,
right,
with such assertion as an expert, almost to say to the jury or the judge, this person is guilty of murder.
Right. And
that's the difficulty.
Right. And that's the thing that can never be taken back.
It can't. And today when he says, I did not appreciate my role as an expert, that is incredible. He understood exactly what his position is as an expert when he hits the stand. If not in his first year or his second year or his third year or his fourth year, certainly halfway through his career he understood that. And he was not daunted by the fact that he did not have adequate training or he did not have the peer review of his work.